You're going to learn about the steps in a criminal trial procedure. Step 1, there has to be a crime committed, for instance, robbery. Then somebody reports the crime by calling 911. I just heard a gunshot. Bang! They investigate to determine the suspect. They collect evidence and send it to the prosecutor. The information is filed, which is the formal accusation. Then there's an arrest warrant issued by the court and an arrest is made. The Miranda rights must be read. The defendant is booked, fingerprinted, and photographed. Then an arraignment is held where the information or indictment is read and the accused pleads guilty or not guilty. They can either be kept in jail or released on bail or released on their own recognizance. If they plead guilty, they'll be sentenced. If they plead not guilty, there will be a preliminary hearing. At the preliminary hearing, evidence will be presented to determine if there is cause to hold the defendant for trial. Then we need to prepare for the trial. We're going to find evidence and continue with our investigation. The prosecution says he's going down. I just found video evidence. Ha! I found an eyewitness to prove that my client is innocent. They're going to be trying to find documents and witnesses as to the facts of the crime, such as videos and someone who can testify as to the time of the crime. Subpoenas might be issued that commands a person to appear in court or produce evidence at the trial. Motions can be made at this point ordering an action to disclose, admit, or suppress evidence. Then the trial procedure starts. At this point, we're going to select 12 members for the jury. They are randomly selected through a list of taxpayers, voters, or drivers. Potential jurors are then questioned by the prosecution and the defense in a process called voir dire. This is done orally and in writing. The goal is to determine who has the ability to judge impartially on the matter. Then have a chance to make some challenges, and that's to get rid of some jurors. For instance, strike juror number 2, she's the defendant's sister. That's called a challenge for good cause. Any ties through birth, marriage, or employment. Or strike juror number 7 just because I said so. A peremptory challenge dismisses a juror without any reason. The jurors are then sworn in. Opening statements are presented. Prosecution goes first. They will present an overview of the trial, of what they intend to prove. Then the defense will go and explain what their evidence is going to show throughout the trial. Then they're going to present evidence. Prosecution will go first with their direct examination, asking open-ended questions like, tell me what happened on the night of the first. The defense will then begin to cross, asking yes or no questions like, did you know the defendant? When they present evidence, they're going to present testimony such as physical evidence like documents and charts, photographs, or weapons. The evidence includes anything that provides information to prove or disprove the alleged facts of the crime. The prosecution then has a chance to redirect, and then the defense can recross. Now the defense calls their own witnesses in what's called the direct examination, where they will ask open-ended questions like explain what happened on July the 1st. Then the prosecution can cross-examine by asking a question like, were you at home at 4 p.m.? Both sides will then give their closing arguments. This is one last chance to win the jury over. Prosecution goes first, and then the defense.
The judge will then give the jury instructions. These are rules of law governing issues of fact that they must decide. In these instructions, he will specify the required elements of the alleged crime that must be shown by the evidence beyond a reasonable doubt.
The jury then goes back to deliberate, talking about the issues of fact in the case, and they will reach a verdict which must be unanimous. Once they've reached their verdict, they'll come back into the courtroom, and the jury foreperson will either read the verdict of guilty or not guilty. If the verdict is not guilty, the accused will be released. If it is guilty, they will be sentenced. There will be a sentencing hearing in some cases where they will hear victim statements, statements of the family, criminal records, or testimonies about the criminal's reputation. The judge will then make a judgment of probation, fine, incarceration, or death. At this point, if there's an issue of law, you can appeal your decision to the appellate court, where that decision may be overturned, changed, or sent back to the trial court. And that's the end of the trial procedure.